Hello everyone and welcome to our YouTube channel Lawyer Stuff. My name is Madhura Kulkarni and in today's video we are going to discuss about Doctrine of Precedent. So let us go ahead. Firstly, let us get to know what is a precedent. Precedent is a judgment or decision of a court cited for a subsequent dispute which is used as an example or analogy for solving a similar case. Article 141 of Indian Constitution says that law declared by Supreme Court will be binding on all the courts within the territory of India. It is a general principle laid down by Supreme Court which will be binding on all the citizens within the territory of India, even though he or she is not a party in the order. Now let us get to know what is a doctrine of precedent. Doctrine of precedent is the decision of the court which will be binding on the subordinate court in the cases which raise the same or identical question of law before the court. Doctrine of precedent has a greater value because it provides certainty. Now let us get to know what are the basics of Article 141. Law declared by Supreme Court will be binding on all the courts within the territory of India, but Supreme Court itself is not bound by its decision. A judgment is supposed to be read as whole. The observation is supposed to be determined before presenting in the court of law. A judgment is considered as precedent only if it resolves the question of law. Now let us get to know what are the types of precedent. First, original and declaratory. Original precedent means where there is a question of law raised which has not been decided before. It applies new rules for the future. Where declaratory precedent means where there is existing rule of law already applied to the case. Second, authoritative or binding precedent. It is also called as mandatory precedent, where a judge has to follow the precedent even if he approves it or not. And third, persuasive precedent, where judges are not bound to follow the precedent, but they have to consider it and has to give the higher weightage to the precedent. Now let us get to know what are the merits of precedent. Consistency. It provides guarantee that every case will be treated in a particular manner and will be decided accordingly. Because of judicial precedent, it is possible, so it provides consistency. Second, it is flexible. As it is said before, that law declared by Supreme Court will be binding on all the courts within the territory of India. But Supreme Court itself is not bound by its decision. It can be changed from case to case, place to place, and time to time. Third, it saves time. As it provides, a couple of points, a particular manner to decide a case. It saves time of court, lawyer also, and the party also. So these are the merits of precedent. Now let us get to know what are the demerits of precedent. First, complexity. It is very complex procedure as it has to go in a certain manner, in a particular manner. So it becomes really complex whether to go with first process or the second one. It becomes a burden on the lawyers also and the judges also to go with it. Every judge has its own opinion, but the judge has to prefer and give preference to the precedents only. Second, it is rigid. As it is said that the law declared by Supreme Court will be binding on all the courts within the territory of India. So it is binding on all the subordinated courts. So it is very rigid procedure and the court has to follow the procedure accordingly. They cannot implement their own procedure. So guys, that was all about Doctrine of Precedent. Thank you so much for watching the video. Stay tuned for more videos. Thank you.